I'm meeting with Jesse Brar, and what's interesting about today is that your background, although you have done some divorce and domestic relations mediation work, you actually also deal primarily in commercial mediation or business transactions. Would that be correct?
That's correct.
Well, before we go any further, I'm going to ask you to give your name and contact information so that if anyone would like to give you a call or meet up with you, they can know where to reach you.
Sure. It's Jesse Brar, and the contact number is 801-577-1988 or 801-269-9541.
Do you have a website or an
Yeah.
email that people can reach you? If you like to keep that private between clients, that's fine, but
No, I do have a website. It's prestonbrar.com, and the email is jesse@prestonbrar.com.
now for those who don't know how you're pronouncing your name or how to spell it, can you spell that out for us
Sure.
as well?
It's Jesse, Jesse, and Brar is Brar.
Okay. So what's your background then? I mean, are you a lawyer? I mean, I know some things that the people watching this don't. Are you a lawyer, not a lawyer, or just give us a little bit of background?
Yeah, I started out as an engineer. I did engineering for quite a few years, went to law school, so I am a practicing lawyer now. I've been practicing for about 12, 13 years, 14 years. I do primarily employment law, and even within that, mostly wage and hour class action cases representing plaintiffs. So most of my mediation experience is also in that area, in the area of commercial litigation.
Just for human interest purposes then, what do you think about raising the national minimum wage?
Oh, I think it's a good idea because, I mean, most people argue that raising the minimum wage will actually decrease the number of jobs because people will hire less. But if you actually look at the data, you look at the places where they've raised the minimum wage.
Mhm.
Seattle, for example. I mean, Seattle has probably lower, unemployment rates than most of the nation, and their minimum wage is.
Yeah, so I was just
high.
curious. It just occurred to me as we were talking about, even though we're going to be speaking about mediation, I thought, hey, get to know Jesse a little bit and some of what he thinks. And so
you consider what raising the minimum wage does. I mean, you allow an employee, a worker who's a member of the society, to be able to buy the goods that you actually make. I mean, that was the philosophy that Henry Ford had, right? I mean,
Right.
Pay people well so they can buy
buy
the
one of my
product
cars.
Yeah, and it's the same philosophy, right? I mean, if you pay employees more, what do they do with that extra income? They spend it back into your same society, in the same community that they live in. And so raising the minimum wage actually increases the number of jobs, and you can see that in places like Seattle, where the number of restaurants actually went up when they raised the minimum wage. So you would think it would be the other way around.
I would have thought that'd be the other way
but
around.
it's not. It's there's this fear, or at least it comes from probably larger employers saying, look, raising the minimum wage, we will have to decrease the number of jobs, but that
Or
doesn't
cut into
really-
our profits. That's
right,
the
it'll
idea,
cut
right?
into the profits, but even that I'm not too sure that it does.
But that's what they're thinking is,
Right.
hey, raise money, it's got to come from raise wages, it's got to come from somewhere.
Right.
I just thought that was kind of interesting. Somebody with your background, people might just say, okay, well, that's interesting to know what he thinks and how, and especially, so you were an engineer,
I used to be an engineer.
and then went to law school, and now you do wage stuff, not engineering related things like
No.
patent or trademark or things like that.
No,
Interesting.
stayed away from the patent and boring trademark copyright stuff. I do employment litigation, mostly class cases. So these are class actions.
So why then? That's an interesting background. Some people would say, hey, engineer, no need to go to school ever again. Go to law school, fine if you'd like, but then why not play to your strengths in engineering? So how did you get to do wage claims?
Part of it, just like most things in life, part of it is it's just accident of circumstances, right? I mean, it's just what circumstances bring you. The other part is trying to do something different than what you've been doing, and then trying to do something where, and this sounds, pretty cliche, because everybody coming out of law school says, well, I want to do something to help the little guy, right? Or I want to do something that's useful to society. This was my way of doing that. I mean, it may sound,
No, I actually
You know,
kind of suspected you might say
you
something
know,
like that
and
because
so-
you certainly had a wide range of choices.
yeah,
your
and
background.
it's just saying, hey, look, there's a need for this. There's this, and you see this in every industry and across the sizes of the industry, small employers to big employers. You see these wage problems.
Yeah, I saw a billboard going home the other day. I was coming up from Utah County, and there's a cheated on your wages.
Yeah.
Call 1-800, and I can't remember what it was. But
Yeah.
yeah. So how did you get into mediation then, too? That's just another step.
Yeah, and you probably know this. Most of the civil cases, and by most I mean like a large majority, 90% or so of civil cases settle before trial. So they go through the steps of litigation, but they don't end up at trial.
Yeah, they may do some steps, but not every step, all the
Right.
way to trial or appeal or something
Right.
like that.
And I think over time, you as a litigator, you realize that even a bad day at mediation, a bad settlement, what you may consider a bad settlement, is still better than a good day in court. There's a lot of advantages to reaching a settlement that you are in control of. Clients control the settlements.
So did you have bad trial experiences that led you to learn about mediation, or have you always thought mediation was good, or?
And no, I always thought mediation was good. The trial experiences weren't bad, but what you realize when you're litigating is you haven't even gotten to the trial, and you're fighting the case for a long time before that. I mean, on TV you see just the trials.
Right.
That's not real practice of law. That's where you get to finally.
How many people went to law school thinking, great,
Yeah.
we'll file a lawsuit, and then next week we'll go to trial.
We'll go to trial.
Then you
And
find out, no, that's not the
It's
case.
like 4 years, or I had a case that lasted, a class case that lasted over 6 years of litigation,
Mhm.
boxes and boxes and boxes of discovery, experts that cost hundreds of thousands of dollars. So there's a huge expense in litigating these cases. So most reasonable people realize, look, I mean, why go through those steps if you can talk to the other side and reach some kind of reasonable agreement? You may not get everything you want, and they won't get everything they want. So you may think that it's not a good outcome, but I feel it's still better than going to trial.
Yeah, and not always, of course. There are some. Just yesterday, I was speaking to another mediator who said, frankly, there are some cases that ought to be litigated.
Yes.
But where you can, look through the facts, and then just say to yourselves, economically, the amount of money we're going to spend to go to trial could end up with a Pyrrhic victory. I may spend $100,000 to get $100,000.
Right. Exactly. Or you may, as most civil litigators sometimes find out, you may litigate a case. Yeah, you may go through the trial. You may win a judgment, but now you can't collect on that judgment.
Exactly.
And so, what did you really achieve? Sometimes in mediations, people say, "Well, I want to fight the case on principle," and I always try to tell them, courts are probably not a good place to vindicate your principles. Courts don't care usually about principles. There are certain rules they follow, and they're going to basically declare one side or the other winner.
And which is
you
a
win,
good
you
thing,
lose,
because if courts could do whatever they wanted, there'd be no predictability, and there'd
Right.
be no purpose in having case law or statutory laws, because you wouldn't be able to say, all right, given my circumstances, what does the law say? I win, I lose. Well, it doesn't matter because the judge can do whatever he wants. So yes, you're correct. I would agree on that there are times when you say to yourself, probably better just to work things out, because I can do more than what the judge may be allowed to do. The judge has to you're a winner, you're a loser. The
Yeah.
judge is constrained by, in criminal cases, for example, I must sentence you to at least this much time under
Right.
these guidelines. Sometimes you have no discretion.
Yeah.
Divorce and family law is the same thing. Sometimes when you go to trial, the court says, well, then you've left me with a choice. I can only choose from 1 or 2 or 3 things.
Right.
Mediation gives you a much broader range.
Exactly. You get to structure the settlement the way you want. For example, you take a commercial case. Let's say it's a dispute over some X amount of dollars. The court's going to say, you win, and this party loses, you pay X dollars to this party. Well, if you were, outside the court, you were negotiating this, you could have the terms that you want. You could, it's in your control. You could say, well, you don't have to pay me X because I know you don't have X at this point, but you can pay me, 1/10 of an X over 10 installments. And
You can
I'll
choose
take
your
that.
interest rate.
And
You can choose
you
your.
can do all of those things, creative things that the court cannot do. They don't have the ability to do that. They don't have the authority to do that.
Let me ask you this then. What about a situation, though, where someone comes to mediation in bad faith? And I mean that in the broadest terms. So somebody thinks, all right, I know about all the advantages of mediation over litigation, but I'm going to game the system.
Uh-huh.
I'm going to use the fact that we can come up with a broad range of solutions to just nickel and dime and confuse the other side and frustrate the other side, or even extort things. What do you think about that? I'm sure
Well,
you've seen that.
Yeah, I mean, if and you probably will see this where people are trying to game either the mediator or the process. They're saying, well, I'm going to exploit this process for my gain. You as a mediator have to be savvy enough to see that. And if you see that the one party or the other is not acting in good faith, it's your ethical responsibility to either end the mediation and say, look, you can't do this. For example, what happens in some civil cases is people will come to mediation because they're going to use the process of mediation to get more discovery. Okay, so I can't get that discovery through court. Since mediation is a confidential process, you're going to give me whatever you have. So, one party or the other wants the other to produce discovery in mediation.
And for the sake of people who don't understand discovery, let's just briefly explain. There's a formal process where you can ask each other for documents to learn, and let's talk about in the context of divorce and family law. I want to find out how much money you make. I want to find out how much you spend. I want to know if you own certain amounts of property or certain kinds of property. I want to see if you have a mistress or a lover that you're hiding someplace from me. I want to know if you take drugs. I want to know if you look at kiddie porn, various things. You can ask for certain things, you can get certain things back, and that's the discovery process, helping you to figure out what we're going to argue about in court and what the issues are and how to narrow them down. But some things are not discoverable, at least through formal discovery.
Right.
So then what happens? People go to mediation thinking,
Yeah, this is where I'll get those. I'll see what the other side has. They can give me discovery, and then I'll take that to court and use that against them.
or use that as a way to find out what I couldn't, or that they didn't have to tell me in formal discovery.
So they have, if they're coming with no intention, like you said, in bad faith to mediation, where they have no intention of actually even participating in the process or going forward to a settlement or anything like that. All they want is this motive that they have to get discovery or whatever other motives they may have. You as a mediator, have an obligation. You have to say, look, this is not a process to do that. If you want to do discovery, court's probably a better place to go back to.
Or there's just certain things you're not going to be able to discover because we won't let you abuse the mediation process
right.
to do what you can't do in mediation, or in litigation, excuse me. I'm glad you raised that. You're the first person that I've spoken to so far that has brought that up. The other thing I want to talk about the bad faith is just somebody who's just kind of driving hard bargains. Now, what's interesting about that is that depends on one's definition of good and bad faith. I may feel like if I can get you to give whatever I can get you to give, I'm not holding a gun to your head. This is a voluntary process. And yeah, I may be able to bring certain pressures to bear. I may know that you need to get something done before you move and start school, or that you may have something that I can use as a pain point. Am I negotiating in bad faith?
I don't think so. I think if negotiating, from whatever strengths you think you have or whatever weaknesses the other party has in their case, I don't think that's bad faith. That's what negotiation is. What I want to do as a mediator is make sure that both parties are informed. They're fully informed of what's going on so they can make decisions based on information. So they're not making some information where they're being hoodwinked by the other side. They have all the information.
There's a difference
You
between
know.
giving advice, which you can't do unless it's solicited by both parties and stuff. Yeah, and some people would say, even if both parties want my opinion, I won't give it. But then there's also as you say, information saying, do you understand the terms being offered? Do you understand the consequences of the terms being offered?
Right. Yeah. And if you're going to make that decision based on all the information, and then you've processed it, and you decide this is the best deal, yeah, then that's a fair negotiation. I mean, I've had cases where you go in a mediation, and you may be surprised that this party is willing to take this offer, and they think that's the best offer,
And they're fully aware.
and they're fully aware. And sometimes you say, well, maybe they could have done better. In your mind as a mediator, you may think, well, they could have done better. But the thing to consider is they have reasons for taking that offer that you may not know.
And we may impose our values on a situation where it simply doesn't apply.
Right. And so as a mediator, your job is to make sure they're making informed decisions. And if they're making informed decisions and they're capable of doing that, then that's fair.
This is a perfect place then for me to ask this. How do you deal with the idea that you feel somebody is being treated unfairly? Because this is mediation, you're a neutral. We've talked about bad faith, and I'm not talking about bad faith anymore. What if you just come across a situation where you think this party is out of his depth? He doesn't realize what's going on. I don't want to impose my values on this guy, but I just happen to know more than he does. He's just a little small, barely graduated from high school, but then he started a really successful company. But he thinks that he's got this outsized opinion of himself. He's being handled by these other guys and doesn't even realize it. What would you say? How do you personally feel? I mean, do you think you should stop the mediation? Should you tell the guy, you really, really, really ought to get an attorney, maybe, with due respect, sir? Or do you just let him go saying he's an adult, or she's an adult, as the case may be, and as long as I don't see anybody trying to cheat, or act in an unethical manner, I'm just going to let this guy have at it? I mean, what do you say?
I think some of those are judgment calls, but one of the things that you as a mediator have to do is to make sure you don't put parties in positions, worse positions than where they started, right?
Is that
So
really your obligation, though?
I mean, it's not your obligation essentially, but you as a mediator have to say, look, if there's a huge power differential between the two parties, and one party, for example, doesn't understand the legal implications of something, or they don't understand, some aspect of their case fully, and they're relying on their flawed understanding of it, I think it's your obligation to say, maybe you should seek other advice. Maybe, and this happens in pro se cases where people think, look, I'm going to go to court, I'm going to win on this because this is, I've read somewhere this is the law.
Yeah, or common sense says I win.
Right, and you have to tell them, and I think it's your obligation to say, look, get legal advice. I'm not going to give you legal advice as a mediator, but I think you should get legal advice so
And
that you're fully informed of the consequences.
Yeah, my own thought would be, I think it's acceptable. I would do this. I'm a mediator myself, and there have been times when I would just say, I can't give you advice, but I've got to tell you, my impression is you have very little or almost no understanding of the implications of what's being discussed. So continue if you will. I can't stop you, but I have to tell you, I really don't think you understand what's going on. And even if the other side's over there going, I can't believe it, we were counting on this differential, it's like, you know what, I don't think it's out of place for the mediator to say, I really don't think you understand what's going on here.
Yeah, and it's in mediator lingo, people sometimes will say it's reality checking with people, and sometimes it comes across harsh. I
might make that guy who didn't graduate from high school feel stupid. That's not my point. It's actually just the opposite. It's like, I want you to be informed, and I want you to make a wise choice, not so much because I'm being protective.
Yeah.
But just saying,
it could be the other way around. Sometimes people are offered a great offer, and you say, you are not going to do any better than this. You can go to court even at the best day that you have in court. This is what you're going to get. the party's offering you more than that. So this is not an offer you can refuse. And people sometimes misunderstand. They have higher expectations for whatever reason, because they've misunderstood their case, or misevaluated their case. And I think it's your job to say, let me sit down with you, ask you the questions, see if you really understand the realities of this.
And just for the benefit of people watching, there are different philosophies of mediation. You look to be, to me, and correct me if I'm wrong, someone who isn't so much actively soliciting people to take your advice, or even any advice, but you're not someone who also just says, really all I'm here to do is make sure you don't come over the desk at each other and fight. But other than that, I'm not going to say anything. I'll call the police if a fight breaks out, but other than that, I'm just here to make sure you don't call each other names, and that we move efficiently and get things discussed and cover everything on the agenda. But other than that, I'm not saying anything else. Where would you find yourself? There's those people at that end, and then there's others who basically, mediators who try to treat, especially people that just can't give up the position of judge or arbitrator.
Yeah.
Where do you fall?
I'm in somewhere in between. I don't think, you have to be neutral, meaning mediator has to have this ability to hold both sides' views as true.
Without favoring anybody.
Yeah, they may be totally opposing views, and you may not even agree with one view or the other. But you have to say, this view is just as good as this view. Or
for the sake of negotiations, I have to treat both positions as equally valid.
Equally valid, equally true. But at the same time, I'm going to make sure that you really understand your position. So if there are, some legal questions that you need to be asking, I'll ask you. That's my job. I think as a mediator, people come to mediators because they do want to resolve their disputes most of the time. And resolving the disputes with all the information includes having that reality checked and saying, look, if you do go to court, what do you think will happen in this case? Well, how do you think this piece of evidence, does it come into the picture? How much role does it play? How much, if it's a case about money, what do you think the damages are really going to be?
There are some who would say, well, isn't that my lawyer's job?
Yes, and usually people come with their lawyers, and sometimes you'll find that, as a lawyer, people want to hear from lawyers that they're going to win. That's what a lawyer does. His role is a little different than the mediator. As a lawyer, you're saying, look, I'm going to take your case, I'm going to win it for you, you have the best case. And what that does is sometimes artificially increases the expectations. And you as a mediator are saying, I'm going to give you the reality. Now, that reality doesn't, may not match with what your expectations are, but if it's true, or if you think this reality actually gives you enough information to change your views, or at least reevaluate your case, then that's my job. That's what I'm going to do.
And knowing that your attorney is only one person, and that the judge in your case is another person, so having another viewpoint, even if it's phrased in a neutral mediator's way, is to say, let me be a sounding board. Let me be a devil's advocate even for a moment.
Right.
Without telling you whether I think your case is better than the opposition's case, I may actually challenge you, not so that you'll take a bad deal, but see the bigger picture.
Right. See the reality in terms of if you do end up in court, what the likelihood of different things is. What are the probabilities?
Or even, I think lawyers who are mediators and skilled neutral mediators, as you've described, add value, because in a sense you're getting a second opinion free of charge in the process. That mediator can say, without me telling you what I think of your case, let me at least give you some questions that one might ask, that may go through a judge's mind. How would you respond to this? Are you prepared to prove this? Do you realize that what you think is a slam dunk may or may not be in the minds of other people who are just as rational as you are?
Right, exactly. I mean, as a mediator, I think you're not like a judge where, like, the spectrum that you were talking about, where sometimes the ex-judges, they're what we would call evaluative mediators, where they're saying, I think this is what's going to happen in your case. I as a mediator, I'm not qualified to tell you what. And nobody is. Nobody knows what's going to happen in court.
Even the retired judge.
Even the retired judge, or even the sitting judge in that very case doesn't know what the outcomes of the case. He doesn't really know which way to go. Most lawyers have seen this. Same judge, 2 different cases, 2 different days, 2 different outcomes.
Yep.
So there's that uncertainty in litigation. Even though it's predictable, there's that uncertainty, and that's what the mediator and the mediation process is supposed to take out for the client, so that they don't have that, and they get to make decisions. They get to control the process, and I think that's the advantage of mediation over litigation. I mean, some cases, yes, they have to be litigated.
As we finish up then, what do you recommend to people in a domestic relations setting, knowing that may not even be the majority of the work you do? What can they do to prepare in advance of the mediation, and what can they do to be prepared for and during the mediation?
So just like in criminal, I mean, in commercial cases, when we prepare for mediation in a commercial case, you're basically preparing almost like you would prepare for trial. You have all the information that you need to when you're with the mediator. I mean, you're going to have a set amount of time, usually a day, to mediate, and within, or anywhere from 4 hours to 8 hours to mediate, and you want to have as much information there as possible. You have all the financial information in a divorce case. You have all the information you need for parenting. Anything else. For example, sometimes people come to mediation and they haven't really looked up their retirement accounts, or they don't have information on how much is the house worth even, or they don't even know sometimes how to evaluate the value of the house. So those are the kind of things you can do prior to mediation, so that when you're at the mediation, you're fully prepared to negotiate, and go forward with the process.
Knowing the value of the house helps you to understand what your options are for disposing of the house.
Exactly.
Knowing if you have a retirement account or what's in it
Right.
helps you to determine if there's no retirement, let's not talk about it.
Right, exactly.
That sort of thing. But
Yeah.
you're right. If we don't, it's like, well, we'll do an agreement that says we'll divide retirement 50-50 if there is any. Well, you may find out that there's a certain kind that isn't vested or is thus and such.
Yeah, and when would it vest, and what could it? Take the example of the house. I mean, you see people and they say, well, I have the information that the property tax value of the house. So we'll split the house. Let's say they're going to, one person takes half the equity and the other person keeps the house or whatever. We'll do it based on this value that is from 2 years, taxes from 2 years ago. By the time they actually reach the court signs on this order, the value of the house may change based on the new appraisal. What do you do with that difference?
Right.
If they had that information before, it makes things easier. So they're not back into that process. And I think most people want our mediation is peace. I mean, they want to get to a point where they can move on with their life, have this conflict behind them. And if you don't have all the information, you leave pieces of that conflict on the table, and then you're returning to those, and that causes additional stress that people don't really need.
I couldn't put that exactly. It just, there's always those unanswered questions, those loose ends that are not tied up.
Yeah.
Jesse, this has been very informative, and I really appreciate how you've taken some of the complexities of mediation and laid them out and made them very easy to follow and understand, because they're very important but often get glossed over because they're kind of technical or not pleasant to have to deal with. They take some effort. You've made that easier for people to understand.
Thank you.
So before we finish up, would you please once again give your name and contact information so that those who want to reach you can?
Yes, it's Jesse Brar, and the phone number is 801-269-9541.
Excellent. Email?
Email is jesse@prestonbrar.com.
Thanks. And we'll also have that printed out next to Jesse's link in the video itself if you need to look at that. Thanks again.
Thank you. Thanks very much.